Okay, so essentially my chapter is around the Torres Strait 8, climate litigation, human rights and Indigenous intellectual property. In some ways, I guess it's part of the constellation of papers that are really focused upon Indigenous rights in the book collection. Perhaps it's a little bit different in certain respects, far from really being around questions in respect of access to genetic resources. Really, it is a paper that is focused upon the destruction of genetic resources and biodiversity. Instead of being so much about the sharing of benefits, it's really about the preservation of benefits associated with a particular place. So really this paper is the latest in a string of papers that I've really done looking at some of the intersections between intellectual property, climate change and Indigenous knowledge. And as is always the case, I would like to acknowledge the Turrbal and the Yugara as the First Nations owners of the lands where QT now stands, and we pay respect to their elders, laws, customs and creation spirits. And we recognise that these lands have always been places of teaching, research and learning. So really, about 5 years ago, I was having some conversations with some barristers in Queensland about prospects for climate litigation. And one of the kind of areas that I kind of mooted at the time was, the potential for an action for climate litigation being run by Torres Strait Islanders. And I guess there's previously been a bit of discussion about the prospects of climate litigation focusing on the Torres Strait Islands. In 2008, Owen Cords Holland wrote a piece considering how Torres Strait Islanders' human rights could be unduly impacted by climate change. There was a bit of discussion in the 2000s in North America about the impact of climate change upon the human rights of Indigenous groups. Also, Kirsty Ruddock did quite a bit of work back in 2009 about whether or not litigation could help Torres Strait Islanders deal with climate impacts. The Torres Strait 8 action, in some respects, harkens back to previous landmark legal action taken by Torres Strait Islanders, like in the Mabo Case. So essentially 8 Indigenous Torres Strait Islanders have brought a case to the United Nations Human Rights Committee accusing the Australian government of violating human rights by not engaging in climate mitigation adaptation. And really, amongst other things, kind of harkening back to an earlier talk today, really kind of raises larger questions about Aboriginal sovereignty and self-determination and kind of control of fate and future. But the litigation has kind of been really interesting, and it's kind of been framed in terms of fundamental rights to culture and life. And also there has been an invocation of the right dealing with privacy and reputation, but focusing upon the part looking at arbitrary interference with the home. So really in terms of the structure of the paper, my work kind of has gone through a few more drafts since the version that I kind of submitted. I mean, in some ways, I've been trying to develop the frame around the central case study, and I've been writing a little bit about international law and some of the crowd surrounding climate litigation in Australia. However, there's so much material in those areas, I might have to go back to my original plan and focus back on the central case study. In some ways, it's a little bit overwhelming looking at the explosion of climate litigation in Australia and the Torres Strait Islands and elsewhere. But in terms of larger international law, really, I think the dispute raises kind of issues around the connection between human rights and climate change. And Michelle Bachelet at the United Nations Human Rights Council has certainly been very interested in that topic. And there's certainly been a kind of a key focus upon climate justice, Michelle Bachelet kind of recently noted in her role as UN High Commissioner for Human Rights that climate change is a reality, that it now affects every region of the world. The human implications of currently projected levels of global heating are catastrophic. Storms are rising and tides could submerge entire island nations and coastal cities. Fires rage through our forests and the ice is melting. We are burning up our future, literally. She has noted that the Human Rights Council has said that human rights obligations, standards and principles have the potential to inform and strengthen international, regional and national policy making in the area of climate change. Interesting enough, she referred back to the UN Declaration of the Rights of Indigenous Peoples, talking about the importance of Indigenous knowledge as being kind of vital to climate action. And she kind of noted that it is essential that the rights of all Indigenous peoples be protected, including their right to freely and fully participate in shaping policy decisions. The United Nations Declaration on the Rights of Indigenous Peoples, I guess, in some ways mirrors some of the rights in relation to civil and political rights and social and economic rights. I guess there are a number of rights within UNDRIP which are relevant to the protection of culture. So particularly Article 8, revitalising and practicing cultural traditions and customs, and Article 11. Article 12 deals with the right to manifest, practice and develop and teach traditions, customs and ceremonies, and have access in privacy to religious and cultural sites. Article 16 talks about cultural diversity. Article 25 emphasises the connection between place and culture. Article 29 looks at the protection of the environment. Article 31, of course, looks at Indigenous intellectual property. The Anchorage Declaration has sought to apply UNDRIP to the Pacific and particular context of climate change. And that has kind of highlighted the profound and disproportionate adverse impacts to Indigenous communities and their cultures, human and environmental health and human rights. And again, there's a kind of a strong focus on traditional knowledge in that statement. We've already heard a lot already about the Convention on Biological Diversity and the Nagoya Protocol and the new Kunming Declaration, all of which try to engage in some ways around traditional knowledge. There's also been some peripheral marginal discussion of Indigenous rights in the context of the international climate negotiations. So often in, say, the preamble around the Paris Agreement, there's a bit of discussion about the need to focus upon the impacts of climate change on the rights of Indigenous communities. The UN Sustainable Development Goals, I guess, also have a number of goals which touch upon important relevant characteristics. So that's just a little bit of a context in terms of the international law behind some of this dispute. In terms of the action itself, really the action is brought by an alliance of 8 Torres Strait Islanders represented by the Torres Strait Land and Sea Council, Gur Barad Hara Cod, along with a legal team from ClientEarth and 350.org. So the Torres Strait 8 include Yesi Mosby, Nazareth Morora, Keith Poby, Stanley Marama, Nazareth Fowd, Ted Billy, Daniel Billy, and KB Tamo. Professor Kristen Lyons observes that the significance of the current appeal by a group of Torres Strait Islanders lies in its potential to lay bare the adequacy or otherwise of Australia's response to climate change as a human rights issue. Amongst other things, they kind of really highlight some of the impacts of climate change upon the physical environment and the biodiversity of the location. So strong emphasis upon king tide, cyclones and coral bleaching, threatening the homes and cultures of Torres Strait Islander people. But really, in terms of the rights that are discussed, it's the right to culture, the right to be free from arbitrary interference with privacy, family and home, and the right to life. And I guess, you know, in the kind of the longer version of the paper, there's a discussion of all those rights, as well as really a discussion of some of the threshold questions of admissibility. So in a previous action involving children's rights, the Committee on the Rights of the Child responded that really the children needed to exhaust their national remedies before coming to the United Nations. And I think that's going to be a kind of a critical issue in relation to the Torres Strait 8. Just kind of quickly going through some of those rights. I mean, as Halle Posdam has observed, cultural rights can play a transformative and empowering role in recognising human creativity, promoting cultural diversity, and in realising other human rights. In the past, as Ebony Black and Rebecca Lucas have commented, Article 27 has been held to impose positive obligations on states to protect Indigenous cultures. I think it's kind of really interesting kind of looking at some of the complaints by the clients of the lawyers in this particular case. And there's a very kind of strong focus on the connection between culture and country and community. KB Tamu kind of noted that we're currently seeing the effects of climate change on our islands daily with rising seas, tidal surges, coastal erosion and inundation of our communities. We're seeing this effect on our land and on the social and emotional well-being of our communities who practice culture and traditions. Kabutamu goes on to say, we have a right to practice our culture in our traditional homeland where we belong. Our culture has a value that no money could ever compensate for. Our culture starts here on the land, is how we're connected with the land and the sea. You wash away the land and it's like a piece of us that you are taking away. Yasi Mobi has also kind of been particularly distressed by the impact of sea level rises on ancestral remains. And there's been kind of issues there in terms of repatriation of ancestral remains and kind of preservation of ancestral remains. The discussion in relation to the notion of the impact upon privacy, family and home is also kind of quite interesting. Danny Belly kind of notes, it's our right to be here, to have a voice, to be recognised and to make others realise that this is our home. In terms of the right to life, Yesi Mosby kind of really highlights that there's an existential threat to the people of the Torres Strait Islands. So the threat of being displaced is one felt across the diverse Torres Strait Islands. This would be a catastrophe for the Torres Strait Islanders. Our land is the string connecting us to our culture. It ties us to who we are. If we were to move, it would be like helium balloons disconnected from our culture. Our culture would be extinct. The legal arguments have been buttressed by the work of ClientEarth. So ClientEarth is now a multinational environmental legal charity. In terms of its philosophy of change, it's about wielding the power of law to bring about end-to-end systematic change, informing, implementing, enforcing the law. So Sophie, who is the lead lawyer, has been very much focused upon framing climate change as a fundamental human rights issue. She's assisted by a couple of other ClientEarth lawyers and various barristers from the London and Victoria bars have also been acting for the claimants on a pro bono basis. And they've also been supported by a couple of civil society organisations, Seed Youth, Indigenous Climate Network and 350.org. There's also significant evidence in relation to climate science. So Leslie Hughes, who's part of the Climate Council, has been kind of giving evidence upon some of the impact of climate change on the Torres Strait Islands. And she has kind of highlighted that, you know, it's absolutely a problem for the Torres Strait Islands now. The longer we delay in either doing adaptation to protect those communities like seawalls and other barricades, And certainly the longer we delay in tackling the root cause for the climate change problem, the worse the problem is going to be. There's also been support for the case by David Boyd and John Knox, the current and the former UN Special Rapporteurs on Human Rights and the Environment. And they have been supporting the argument. And I guess it's noted that recently the United Nations Human Rights Council has recognised a right to a healthy environment. So that should provide an extra dimension to the topic. In response, the Australian government has said that its current policies regarding climate change are consistent with international human rights obligations. And they've also argued that the case should be dismissed because it concerns future risks rather than present challenges. And in my paper, I kind of elaborate upon some of the larger arguments that Ken Wyatt makes about policy commitments that has been made by the Morrison government. In a final reply, the Australian government has denied responsibility for climate change. It states that really Australia has done enough, and in any case, no one single government could or should be held responsible for climate change. The Torres Strait 8 have responded to Australia's arguments, and we're kind of now waiting for some sort of final decision. Yessi Mosby has emphasised that the government has a duty of care, and that duty extends to all Australians, not just for the people who live down on the mainland. He implored the Australian government to tell the truth. You are not trying your best to help us. Stop lying. The Torres Strait 8 have also been running a kind of a political campaign and have been seeking a petition to try to call upon the Prime Minister to protect the Torres Strait Islanders from climate change. And Yessi Mosby has recently just issued an email statement about the next phase of the Our Islands, Our Home campaign. So in the lead up to the 2022 federal election, he wants to make local politicians listen to their demands. And he has explained, our vision is to burn a fire in the hearts of people calling for climate justice. We want to organise big storytelling events and get Torres Strait Islander voices in the media. Thinking about this dispute, I really kind of came to the conclusion that there is a high likelihood that it could really spin out into a domestic action. Whatever happens in terms of the international action in the United Nations, it could well be the case that the Torres Strait 8 pursue domestic climate action against the federal government. I wrote a good 5,000 more words on this, but I'll just kind of quickly note that a number of recent precedents are pertinent and relevant to the dispute. So the Rocky Hill litigation, Chief Justice Preston, amongst other things, talks about the impact of mining upon Indigenous cultural heritage. And he kind of particularly notes that you need to take that into account in terms of an assessment in relation to climate change. That action was successful. There's been another successful action in terms of bushfire survivors for climate action against the New South Wales EPA. I guess that is relevant in terms of that being a kind of really a piece of climate litigation about a disaster. And I think the Torres Strait Island complaint, amongst other things, is really raising concerns about climate disasters impacting upon their way of life. The precedent of Sharma versus the Minister for the Environment is really important in terms of recognising that the Australian government has a duty of care in terms of looking after particular key communities. That case is under appeal at the moment, but I think it's worthwhile thinking about in terms of what duty of care does the Australian government owe to the Torres Strait Island 8 and Torres Strait Island communities. There's an action being brought against Clive Palmer. That is of interest because it invokes the Queensland Human Rights Act, which amongst other things recognises a right to culture, a Pacific right in relation to Indigenous culture, a right in relation to life and a right to object to arbitrary interference in relation to home. So that case is still to be determined, but it'll be interesting to see its relevance. There's another Queensland action on foot against Adani. It'll be interesting to see how that plays out by North Queenslanders. So we think about this dispute as a North Queensland dispute. Maybe that might be of interest, given this particular action really focuses upon the Torres Strait, or this one focuses upon the Great Barrier Reef, and it might be of relevance to the Torres Strait Islands. There's been various disputes between traditional owners and Adani. There has really, interestingly enough, been the invocation of the right to culture for Indigenous Queenslanders in disputes with police. So traditional owners and custodians have been visiting Adani lands, and Adani have been arguing that they've been trespassing. The Queensland Police have now recognised that the traditional owners and custodians do have a right to culture, and that also deals with looking after local business on that land. So that's an interesting dispute that it's emerging. There's climate litigation going on in relation to the Murray-Darling system in relation to rivers, and there have been Indigenous complainants concerned about that. There's also been some financial actions, O'Donnell versus the Commonwealth, McVeigh versus Rest. There's also lots of comparative climate litigation going on as well. I guess we should contextualise this action as one of many in terms of the action around the world, making some connections to what Daniel was talking about before in relation to Vanuatu. Vanuatu has just sought an advisory opinion from the International Court of Justice on climate change. So thinking about climate change impacting upon small island states, there's been lots of parallels drawn between the Torres Strait Islands and some of the interests of some of the Pacific Islands. Previously, I've written about Indigenous climate litigation in Alaska and the Nelson Cannock case, but all sorts of climate litigation on foot in the United States, including Indigenous climate litigation. The Uganda decision has been a really important decision in the Netherlands. There's other action like the People's Climate Action in the European Union, which also involves some Indigenous complainants from some of the Nordic states. As I mentioned before, the children's rights climate action in some ways was unsuccessful at a procedural level, and the children have been told that they have to bring national action. But in terms of the substantive comments, there was sort of recognition that climate change did impact upon children's rights, and governments did have responsibilities to protect children's rights. And just yesterday, there's been a new complaint made by Australian youth to UN Special Rapporteurs over climate inaction. One of the members of that action is from the Torres Strait, and there's also another Indigenous complaint in that particular matter. And there are complaints about the impact upon human rights, Indigenous rights, and disability rights. And I guess that's part of, waves and waves of climate litigation kind of happening at the moment. Just to wrap up, I think this is a really interesting dispute about climate change and human rights. I do think it kind of raises larger questions about the connection between culture and country, and the relationship between cultural rights and Indigenous intellectual property. And kind of reading the kind of complaint, I think there's a really strong connection there between biodiversity and some of the issues being raised by the complainants in relation to the Torres Strait 8. But I think, thinking about the Convention on Biological Diversity, I think we really need to kind of grapple with destruction of biological diversity and associated culture. And it'll be interesting to see how this action kind of provides inspiration for other actions. Perhaps the Vanuatu action is going to spark some more action in the Pacific. There's lots of other possibilities in terms of Indigenous-based pieces of climate litigation. But really kind of coming up to the COP26 Global Climate Summit next week. Really, I think the dispute also highlights the struggles with getting proper representation of Indigenous communities in the international climate negotiations, but also the failure of those negotiations to provide substantive protection in relation to Indigenous rights. It's little wonder that many Indigenous communities and First Nations communities are looking to the courts to try to address the lack of progress at a national level and at an international level. So thank you very much.
Thanks, Matthew. Fran, are there any questions on the chat?
No, no questions I can see on the chat.
Can I make a comment as opposed to a question?
Yeah, sure.
Oh, thank you, Matthew. That's really good because it gives us the context for the broader issues. And what I guess what it shows us is that ABS is perhaps on the edges of these kinds of bigger debates. But clearly it's to do with the environmental impacts. As we say, ABS is in environmental legislation, and there's that bigger canvas. And so thanks for giving us a summary. That was really good.
Yeah.
I guess I'm surprised by how much litigation there is. Is that just the sort of the tip of the iceberg? Or is there just a lot in train? Are we going to see a lot more of this kind of thing?
Well, there's a lot of in train in Australia. So all those actions that I talked about in terms of that long list of Australian actions was really actions that have been brought in the last year or two. Some commentators like Jacqueline Peel had been very pessimistic about the chances of success for Australian climate litigation. Often it was thought that it would be much harder to bring climate litigation in Australia. We don't really have a system like the European Union or the United States. But nonetheless, there have been a few breakthrough precedents. Preston has been very influential as an environmental judge. But the federal court decision in Sharma, I guess, is a kind of quite a groundbreaking decision as well. But there has been, an incredible amount of global climate litigation going on. The Sabin Centre kind of keeps a set of databases trying to keep track of all the different forms of litigation, all the different species of litigation. And I guess there's very systematic efforts to work through different sorts of strategies. And I guess we're really seeing now also some different international strategies in terms of going to United Nations bodies, like with the Torres Strait 8, or going to UN special rapporteurs, like the new action that was just announced by Environmental Justice Australia yesterday, or the International Court of Justice action that is being brought by Vanuatu for an advisory opinion. It's kind of very dynamic. I would say I do think that there is a very strong connection to the ABS if we think about the ABS in terms of being fundamentally about the protection of traditional knowledge. So I see this climate dispute as really an effort to take legal means to protect cultural rights and traditional knowledge. While it's not really traditionally within an ABS framework, I do think once you start digging through what the complainants are actually arguing in terms of the impact of climate change upon their lands and waters and genetic resources and traditional knowledge, I do think there's some very kind of interesting connections there. But yeah, given the 5,000 word limit, I think I've written 20,000 words in my excitement and enthusiasm in participating in your great collection. I will certainly have a think about how I'm going to bring together some of that framing material, because even I was just a little bit shocked about how much material there was in terms of some of those adjoining areas. But having a look at the other book chapters, I can see that you've written a kind of a book chapter really focusing on some of the international law particularly around some of those issues. We've just heard another kind of paper looking at the Pacific Islands. I think I'm going to try to go back to my original conception and hone down a piece upon the dispute itself and try to use the references to draw in what else is happening elsewhere in terms of international law and in terms of other climate litigation. But maybe the dispute will take on a different form once we know its outcome.